Abundiz, okay? Whenever you're ready.
Well, good afternoon, Your Honors. This case was rather difficult to, obviously the facts of this case, the facts and circumstances of this case, I'm not going to go over them. The government and I are pretty much in agreement that that everything that was in the record is actually what had happened. The issue comes now as to whether, with regards to the several legal holdings in this case that were done all together, seems to be a cascade of I guess, for lack of a better word, piling on. The first was the allowing the little girl to testify under closed circuit TV, under Craig, under 183509B. And Judge Montalvo, the district court judge, did a really good job of laying all of the elements out under Craig, and it's required under 3504B1B2, and that the child in order, if she were to testify in front of the defendant, there would be fear, and that there would be suffer further emotional harm or trauma. And one of the experts had testified even that in instances when the child has to come back to court and testify, that the child, it's almost a re-traumatization, because they are, the people who are safe, the people that are telling her will keep her safe are now the ones presenting her to testify. And that was the whole reason behind Craig and then 3509. Okay, so that alone is not the point that we were trying to make in our appeal. I think what we're trying to do, is that you have to look at the other issues that were involved in this.
I'm just going to interrupt. In your brief, you were clear that you said the error was the district court had not made the finding that corresponds to 3509. Then yes. The government replies in its brief and points and quotes from record 389, 398, 399. But then you don't have a reply brief. So were you mistaken in that position or not?
No, I was mistaken, Your Honor. I do apologize.
Okay, well, you should, as soon as you realize you're mistaken in a proposition, you should tell the court.
My apologies.
Okay, so do you have anything left that you've preserved under 3509?
No.
Okay, so when we shift to Craig, are you saying that that existing law, the court had to follow Craig, but you want to preserve the error for later, that maybe it's inconsistent with Crawford?
Yes, that's correct.
So you're not asking us to do anything. You're just saying you want to preserve the issue for the possibility the Supreme Court will adjust Craig in light of Crawford? But be very careful how you answer that. You are not presently asking us to follow any law you've cited to us that suggests that Crawford has adjusted the Sixth Amendment analysis we do in Craig.
That is correct, Your Honor. Crawford has not extended it past to these.
So what's the argument left? I don't mean to cut you short.
No, it's okay.
What's your argument for reversal of this life sentence on a single count of 2241?
Your Honor, the other points, and that's what I was getting to with regards to the other counts or not the other issues I presented. The testimony of the two women who were sexually assaulted in the past, as well as to the pornography that was found. Individually, as you look at them, they all satisfy, they check off the boxes. If this were a paint by numbers, the district judge did exactly what he was supposed to do. However, the standard is a preponderance of evidence when it comes to these two type of cases. And so when you're instructing the jury that they find by a preponderance that these incidences took place, then the jury is free to review them. There's still a 403 analysis of the probative value of prejudice, but ultimately...
Did you object to the use of the Eighth Circuit since there's no Fifth Circuit pattern? Did you object to the instruction given on how to assess Ms. Rosales' the step-sister's testimony?
No, that was not presented in the...
You are arguing on appeal, so you're saying it was plain error for the... Is that your argument?
Yes, it is plain error. They didn't preserve the error.
But what's wrong with the Eighth Circuit as it was modified by the district court? What's the error? Because you didn't ask for an instruction of your own.
No, we did not. I wish I could tell you that there was something wrong with the Eighth Court's instruction. It isn't. There isn't.
Your position now is just there was an improper balancing on 403 as to the child pornography and as to the
testimony of the two other individuals who testified.
Okay.
And that is correct. I'm asking the court to adopt a higher standard than what is normally required in cases involving these type of fact patterns. This is the classic case of he said, she said. There's no DNA, there's no sane rape test, there's no witnesses who walked in on them, there's nothing but just the little girl's testimony versus Abundiz's denial. And in that instance, when you allow, that by itself is a very weak case. It's difficult for the government as well as the state cases that prosecute these all the time to come into, because children a lot of times don't testify well. They don't do well in front of juries. And so, but nonetheless, just because of that, just because you have that kind of circumstance does not necessarily mean, and this is where I started off, that you get to pile on evidence until you bring the weak case up to being strong. And quite the contrary, one would assume that if that's your case, I mean, if the government's case is solely based on the testimony of the child victim, and if the government is going to present all of these other extraneous acts, then the standard has to be higher than what we currently ask for in our with regards to our law. And so that's why I'm asking the court to take into consideration.
The district court didn't admit all the 404B, right? Right? Wasn't there some canal incident that the district court said that's not coming in?
That's correct. He did not let them go into that one. But all the other incidences, the two women, as well as the discovery of the child pornography on my client's phone.
But your client confessed to that.
That's correct. And so all of it came in. Unfortunately, I did not find where the defense counsel had filed a motion to have a Jackson v. Danille hearing with regards to his statement, so that issue was waived. And even if then, I don't think we could have gotten there. But that's what I'm arguing, Your Honor. Basically, that when you have these type of cases, and only these type of cases, because as I was thinking about my argument this morning, if I'm asking the court to have this higher standard, what evidence do you pick and choose? And so, what crimes constitute this picking and choosing, this cherry picking? And so my position is, in these certain instances where the evidence is reliant solely on the child testimony, if the government's going to introduce these extraneouses, there should be a higher standard.
Okay, thank you, counsel.
And that's, if there's any other questions, Your Honor.
You save time for rebuttal.
Thank you.
May it please the court, Daphne Newaz for the United States of America. Your Honor, based on your questioning of appellant's counsel, I'd like to go ahead and discuss just briefly the issues of Maryland v. Craig and the 3509B. If you have specific questions, I'm happy to delve into it.
It didn't sound like it sounded like he conceded both of them.
It does. And so if Your Honors would prefer me to move on to other issues, I'm happy to do that. Or
some scholarship that's questioning whether Craig, but you only cited an old 10th Circuit case, Farley, 1993. Do you remember?
Yes, Your Honor. And
Do you have any cases applying, Fifth Circuit cases applying Craig post-Crawford?
I don't believe so, Your Honor. And Your Honor, there is some scholarship asking sort of, I think, the question of what Crawford does to Craig and what, should be done in the future. But I think that, based on concession, but also just based on the facts of this case and considering all of the other circuit case law, Judge Montalvo did exactly as he was supposed to do, and the facts as laid out, as supported by the testimony of Dr. Lubit, everything that needed to come out about why KZ was afraid of the defendant, about why it was a necessity for her to testify via closed-circuit television, came out during that
The argument, not so much in the brief, but at trial was, she's been interviewed 6 times by the government, right? Mm-hmm. And sadly, she's had an immense amount of trauma in her own family. And that was, if I remember, the defense attorney said, therefore, there isn't the likelihood of trauma if she doesn't have a face-to-face. You recall those arguments?
I recall those arguments, but that wasn't what Dr. Lubit testified to based on his being an expert in child and forensic psychiatry in the 3 different times that he actually interviewed KZ. He found that each and every time he interviewed her, even if there was another adult in the house, and even though it was just one-on-one, just him and her, she could not talk about the incident. She stated that she was afraid of the defendant and that she would have a problem having to
She was a
face
second grader at the time of the incident. How old was she when she testified?
Your Honor, I don't recall that off the top of my head. I apologize.
No, that's right. Did she stated directly to the EMT and the nurse what had happened to her, correct?
That is
Did they then
correct.
testify?
They did, and that did come into evidence as well, Your Honor. Yes, during the same nurse's testimony. In the order when the judge was considering whether to admit the other act evidence under 413 and 414, he also considered whether those statements that KZ made to the same nurse should come in, and he ruled that they should.
Trial defense was it's a false accusation because the spouse is a malevolent person and she was a very troubled person, correct?
And or whether there was some mysterious other person named Juanito that possibly could have committed the sexual assault. I think there were quite a few sort of theories that the defense focused on, Your Honor.
You want to speak to the one issue he pressed, which is,
Yes, sir.
a lot of other act evidence came in. It turned on just one young girl's closed circuit TV. Everything was a he said, she said. So the government basically convicted him with other act evidence.
Yes, Your Honor. That is what 413 and 414 of the Federal Rules of Evidence contemplates, specifically that allegations of sexual assault, that is a swearing match, and that Congress aimed to assist the fact finder's assessment of credibility by allowing the introduction of extrinsic evidence of sexual misconduct. So that is the entire purpose for why 413 and 414 are there. That being said, even though those other acts come in, the district court was required to and did apply the 403 balancing test. Your Honor already pointed out one specific thing that he did, which was he did not introduce any testimony or evidence regarding Abundiz's, I will call it the rape of MR, but specifically it was that his penis was touching her butt in the canal incident. He found that under Rule 403, that introduction of that evidence would not fit the Rule 403 balancing test. And so
We don't have a pattern instruction in 413.
we do not.
So what exactly did the judge do? You proffered the 8th and the 9th, and he modified the 8th?
Yes, so with regard specifically to the jury instruction, what the district court did was he looked at the available pattern instructions that existed, specifically from the 9th Circuit and also from the 8th Circuit. He did, and he recessed court. He took a great deal of time and very methodically went through the 8th Circuit pattern jury instruction. He noted when he was going through it, that it utilized the preponderance of evidence standard, which is the correct standard here in the 5th Circuit by which the jury is supposed to weigh the 413 and 414 evidence. That's from United States versus Dillon. So he analyzed the correct standard, made sure it was in there. He found that the sentence that the 8th Circuit uses after that, which was whether the evidence was believable or not, seemed too muddy the preponderance standard, and so he removed that and instead repeated the preponderance standard. He found that the 8th Circuit utilized some of the wording that is similar from 404, mistake and accident. He found that could have tended to confuse the jury, and he basically simplified it. He essentially utilized the 9th Circuit's pattern jury instruction, but made sure to insert the preponderance standard, which is the applicable law in the 5th. And as Your Honor pointed out, and as has been conceded, there wasn't an alternative proposed by Abundiz. Abundiz did not want any instruction whatsoever, which would have been a very big problem if that would have occurred, because then the jury would have had no idea how to weigh the 413 and 414 evidence, which did come in at trial. That being said, Your Honor, even if somehow Judge Montalvo abused his discretion in crafting that instruction, that would be harmless. When and the thing is, I'm not sure what the error is. So upon a look at what he crafted, it appears to state the law as it should, and it literally takes the text from 413 and 414 as to considering the matters to which it's relevant. So I'm not sure what the error is, but even if there was one, there is nothing in the record or otherwise before this court illustrating that that error somehow contributed to the jury's verdict.
Okay, counsel.
Okay, thank you very much, Your Honor.
Thank you. Mr. Lopez, do you have rebuttal?
Very brief. Your Honor, I just want to make sure that I was, when we first started out, you told me to be very careful how I answered the question with regards to Craig and Crawford. And I want to make sure I don't waive that issue, that yes.
Well, you've preserved it for further review, but you've stated that we're bound by Craig.
That's correct.
Okay. Thank you, counsel.
That's all, Your Honor. Thank you.
All right. We appreciate that. Case is submitted. We'll call the second case of the day, 23-502.